So I'm getting a lot of questions about Subrosa, otherwise known as surveillance video of the plaintiff. And how do I get it from the defense? How do I discover it? How do I see it ahead of time? Well, first of all, the actual video, the surveillance video, also called Subrosa, is work product. It's covered by the work product privilege unless it's waived, unless it's disclosed. And so while you're not able to see ahead of time the video until it is chosen to be disclosed by the defendant, there are a lot of ways to kind of suss it out, to learn about whether it exists, etc. And I want to talk about that for just a little bit. So while video itself is covered by the work product privilege, the fact that video has occurred, the name of the person who took the video, the dates and the times of the video, and the existence of any documentation, reports, etc., is not covered by the work product privilege. Now, the report itself is work product. The video itself is work product. But you are entitled through discovery to know that it's happened, when it's happened, and by whom. And in California, that is one of the form interrogatories that is required to be answered. So first of all, if the defendant has done this kind of Subrosa surveillance, before they have to respond to the form interrogatory response, if there's anything other than, no, we haven't done it, then you need to follow up. They many times object attorney-client work product and then don't answer the question. Right? You have to see this and you have to follow up. It specifically, in fact, asks in individual subsections for all that information. The reason you want to do that is that if you don't follow up, then they basically haven't told you if they have it or they don't. That's why you always ask for a privilege log whenever there's any privilege asserted in any discovery. But many times, defendants know this. They know that they have to disclose it in form interrogatories. And so they won't do surveillance until after the responses are due. So they say no surveillance. And then right after that discovery response, they start doing surveillance. And when is it most likely that they do surveillance? Well, when they do a medical exam for the defense, they know that the plaintiff is going to be in a certain location at a certain time. And so they hide out and they wait and they film the plaintiff as they're driving up to the medical office, et cetera, trying to hope to catch that, they walked in without a cane, they walked out with a cane, et cetera, et cetera. They also do quite a bit of surveillance right around the trial date, especially after discovery has been cut off. How do you prevent this? At least, how do you get more knowledge? Well, in California, at least, you can send up to 2 requests to supplement all of the responses. If you don't have a trial date yet, then you can do it twice before discovery cutoff. In other words, you can do it once and then you get a trial date, then you can do it again. And if you have a trial date already, then you can supplement 1 additional time. And so you always want to save your supplemental discovery request for right before the discovery cutoff, which is basically in California, 60 days before trial. You want to send a request for them to update it. And now if they've done any surveillance within 30 days of trial, they have to disclose it. And if you got a no and you've pushed to get an answer early on, and then all they say in their supplemental is no additional information, and then later they try to use surveillance that they took during that period, it's excluded. Other things you want to do. I always want to send a trial subpoena, especially if I know the names of the people, for their files, for Subrosa, for surveillance. Sometimes it works, sometimes it doesn't. I always want to try to catch the defense kind of off guard as we're talking to the judge, getting ready for the motions and et cetera. We're about to pick a jury the next day. And then I'll say something like, and Judge, I just want to make sure if there's any surveillance or sub rosa, I need to see all of it. And if there's a lot of it, I got to have a lot of heads up. And then I'll look at the defense and I'll see if they tell, right? If they say, oh, I'm not saying if we have it or not, but and sometimes you can tell, oh shit, they got it. And the last part of this is that in a trial, once they've talked to the defense, once they've got the plaintiff on the stand and they've questioned them, and usually they've got surveillance if they're like, well, is this a true statement that you cannot carry grocery bags that weigh more than 22.7 pounds 500 feet from your car to the store? But I'm like, oh, they got a video of that. But what's really important is that as soon as they finish with the plaintiff, you need to raise with the judge. If they have any surveillance that they're intending to play, not only do they have to show us what that is, but we're entitled to the entirety of all surveillance ever taken and any reports, etc. Because if they play 15 seconds of surveillance and they took 5 days of surveillance and the other 4 days and 99% of the day is the plaintiff not moving, looking like they're hurt, etc., you want to be able to either show that or at least argue, look, they spent 5 days and they got 15 seconds. And then lastly, many times first of all, they have to establish foundation for the video. So they got to call the people or person who took the video, right? This is a ripe source for cross-examination where I want to say, you staked them out for 5 days and all you got that we showed that you're going to show is 15 seconds. Sometimes I'll say what you saw was somebody who was sad, somebody who was depressed, somebody who didn't move around very much. Well, 5 days, I only got a total of 20 minutes, right? So for 5 days, for 4 and most of the rest of those days, the plaintiff never left their house. Isn't that true? Right? So you try to make what you can of the lack of video despite the amount of time that they took, right? And then sometimes I'll be like, and you also not only work for defense firms, you've been hired by every insurance company in the book because you are hired by these types of entities and law firms to do nothing but try to dig up dirt. And you don't turn the camera on unless you think there's dirt. And you leave the camera off if it's not helpful to the defense. True? You got to deal with what. So if you got any questions about this, if you need forms, if you need like that privilege log request, if you want the subpoena or the request for production for the Subrosa, if you want motions in limine to the extent we have them about Subrosa, just reach out. My info's in the bio. It's in the video description. I kind of love this stuff. I've been called a very, very funny law geek, right? Now I run a firm. I run a big firm. I do a lot of different stuff. I'm an excellent pickleball player, but I humbly accept the label of law geek because I love this stuff. I want to help you with it. So please reach out.